Namaste and welcome to the presentation on special contracts. We will cover under special contracts quasi contract, contingent contract, indemnity and guarantee, bailment and agency. And to complete the story, we will also add the small topic on e-contracts. A brief summary of the subheads under which we will be studying these special contracts, and it will be more relevant once we complete total presentation. A brief summary of e-contracts which have got some unique features. They are in electronic form and the media that is used is website and emails, and they are modeled and executed by a software system. E-contracts are more effective because of their speed, accuracy and reliability. They are digitally signed and the digital signatures are obtained from certified authorities under due process, and they are covered by Information Technology Act 2000. And e-contracts have to follow the Indian Contracts Act in terms of the basic minimum requirements of a contract, say under section 10. And except for the media that is used and the way it is implemented, it is on par with traditional contracts in terms of its validity, sanctity and strength. We will study special contracts under 6 heads and make a beginning with quasi contracts. Quasi contracts are not as such mentioned in the Contracts Act. They are contracts which are not in perfect compliance with the requirement of section 10, but they are known as relations resembling contracts, and this is what is mentioned as the chapter head under section 68 to 72. The basic spirit of relations resembling contracts is there should be no unjust enrichment of anyone, and this goes by the principle of law of equity and good conscience. Although there is no agreement, if there is something which creates a relation resembling contracts, the party who benefits has to pass it on to the party who really deserves it. For example, you start a magazine and you commission a writer to make an article, and he writes the article and sends it to your magazine, but your magazine somehow doesn't hit the market. This doesn't mean the writer who wrote the article, he should not be paid, because there is no project of yours as the magazine has been closed. But what quasi contract says, since the writer commissioned to write up has finished his job, he has to be paid, and the principle is of quantum merit, as much as deserved. The writer deserves to be paid, and this is the basic principle of quasi contract. There are 5 components in quasi contract. First one is supply of necessaries. What it says is, if you supply necessaries suited to a person who is incapable of entering into a contract, or you supply such necessaries to people who are legally bound to be supported by this person, or to a lunatic or his dependents. If the necessaries are supplied to any of these people, it comes under section 68, supply of necessaries. The person who makes the supplies is entitled to be reimbursed under the principle of quantum merit, and he can get his money repaid to him out of the property of the person who is capable and on whose behalf the supply has been made. Once again, the principle is there should not be any unjust enrichment. Second is payment by interested person. Here, a person who is interested means he has got a stake in the payment, whereas the payment was supposed to be paid by another. Example, you stay in a flat and the electricity bill comes. Electricity bill has to be paid by the landlord. But if you don't pay the electricity, there will be disconnection. As a tenant, you are interested in making the payment of electricity, which the landlord is bound to pay. This principle says when you make a payment in which you are interested and some other person is required to pay by law, you can pay the amount and you are entitled to be reimbursed by the other. This applies to even land revenue payment also. It is paid under legal compulsion. Only requirement is the payment has to be made to another party. You can't pay it to yourself. And it should be established that you have an interest in making the payment on time, as we saw in case of the electricity bill. That is section 69. We have a third item which talks of liability to pay for non-gratuitous acts. Acts which were not supposed to be free or charitable. You were supposed to pay for it. What is its detail? Where a person lawfully does something for another person, or he delivers anything to him, and his intention was not to do it gratuitously. He has done something, he has delivered something, it was not supposed to be free, and the person who received has enjoyed the benefit. And when he has enjoyed the benefit and the supply was not for free, he is bound to make a compensation or restore the things so delivered. Means if someone has given you something and it was not free, you enjoyed the benefit, you are supposed to pay for it or you are supposed to return it. And that is the principle of liability to pay for non-gratuitous acts under section 70. He gives one more example. A leaves goods at B's house by mistake. He didn't want to leave it there. What B did was, B used it. For example, he left apples and B ate the apples. But that apple was left without any intention and it was not supposed to be free to them and they were not supposed to use it. Since they have used it under the principle of section 70, they are supposed to pay A or return the apples in the original form or similar apples they are supposed to give. That is section 70, liability to pay for non-gratuitous acts. Then finder of goods under section 71. A person who finds goods belonging to another and takes into his custody. You find something on the road and you take it. And when you take someone else's goods, you become a baily. We will look into baily as a definition separately. Now for the time being, let us see. Your responsibility is that of a baily because the item doesn't belong to you. You have collected it when you found it. What is your job then? You have a responsibility to protect the item, not to mix with your items. You may have similar items at home and your job is to search the owner and try to find the owner and pass it on to him. Before pass it on to him, you can ask him to pay the reasonable expenses you incurred while preserving the item. And the law also says when you have found something and kept it with you, and if it is a perishable goods, you have got a right to sell the item if it is diminishing in quality, or the cost of preserving it exceeds 2/3 of its realizable value, you have got to sell it. And if you don't do these things 1 to 5 and you enjoy a good belonging to someone else, you have made an offense which is called an act of conversion under section 43 of Indian Penal Code, which means dishonest misappropriation of movable property. It is as good as you have made use of someone else's property which didn't belong to you. It is a undue gain and unjust enrichment on your part. And in respect of those goods which you have collected and you have gone in search of the owner and trying to return it to it, or if it is perishable you are selling it, you have got certain rights. You have got a right of lien. You can hold that property till the real owner pays you back your expenses. Compensation, he reimburses you. And if he has made an award that I have lost this, whoever brings that back to me, I will give an award. Just we saw in case of Lalman Shukla versus Gauri Dutt. He can get the award. These are the 3 rights. Retain the goods till you are settled, get compensation for expenses you incurred, and if he has declared a reward, you can claim the reward. And this is all coming under section 71, finder of goods. And we have got one more 5th item, benefit received under mistake or coercion. Simple. A person who has received money or goods by mistake, or he collects it under coercion from somebody, what is his job? He should repay or return it. For example, bank credits your account wrongly by 1 crore rupees. It doesn't belong to you. It is undue gain. It is an unjust enrichment. What is your job? You should repay it or return it. And that is covered under section 72. Here there is an example. A and B jointly were to give 100 as loan taken from C, and they decided to repay. By mistake, A and B, instead of paying jointly 100, each of them paid 100 each. In the process, C got 200 and he has got an unjust enrichment, benefit received under mistake. What is his duty? He has a duty to refund the excess of 100, similar to wrong bank credit what you received. These are the 5 principles which are covered under quantum merit. Even though there is not a formal regular contract complying with all requirements of the Contract Act, it is covered under section 6872 under the head Relations Resembling Contracts, which is also referred to as Quasi Contract outside India. We will continue the topic with Contingent Contracts. Contingent Contracts is a contract to do or not to do something. If some event we will do or not do something, if some event which is collateral to such contract happens or doesn't happen. 3 things we are talking of. We are talking of doing or not doing something which is related to some event. Where the event does happen or doesn't happen, we will do something. This is the relationship in a contingent contract, where our doing or not doing depending upon the happening or not happening of another event. For example, A agrees to pay B rupees 10,000 in the event B's house is burnt. Now, what A agrees to do or not to do something? A agrees to do something. A agrees to pay B. If some event Some event is the damage, burning of the house. If that house does or does not happen, if the house is burnt, A will pay B 10,000. This is a contingent contract. Meaning, if the house is not burnt, A is not going to pay B. It is contingent. It is contingent on the happening of an event. The party will do or will not do something. Now, this contingent contract is covered from section 32 to 36. And here, to understand each of these 5 classifications, we have to go by a tabular approach which will help us. We will study section 32, 33 and 34 with reference to this table, and for a better understanding we will be toggling between the two. Let's have a look at it. Section 32, let's understand this. Contingent contract means to do or not to do something if an uncertain future event happens. Under section 32, to do something or not to do something, if an uncertain event happens, the event has to happen. It cannot be enforced unless it happens. For example, if someone says, if by 4 p.m. today, if it rains, I will pay you 1 lakh rupees. By 4 p.m. it should happen, it should rain. If the rain has happened by 4 p.m., then you can enforce it. And let us suppose for the whole of afternoon till 7 p.m. there was no rains at all. What does it mean? The event has become impossible. It says until that event has happened, you can't enforce it, but if it happens, you can enforce it. If the event becomes impossible, till 7 p.m. if there is no rain at all, you cannot enforce this contract because it said, if it rains, we will pay you 1 lakh. If it didn't rain, the event became impossible and it became void. This is what section 32 says. We have to read it through this. Let us go to next section. Section 33. Contingent contract, to do or not to do anything if an uncertain event, we are talking of section 33, does not happen, the event shouldn't happen. It can be enforced when the happening of that event has become impossible. And he gives an example. What is that example? A agrees to pay 1,000 to B if a ship doesn't return by end of May. Let us suppose we are end of May 2020. Now, as per this contract, the ship should not come till end of May. It doesn't come at all. We come to mid of June. Then the event has become impossible. It can be enforced. Does not happen can be enforced when the happening of that event become impossible. Or even before May 20, the ship sinks somewhere in the high seas. And what he has said, if the ship does not return, since it has sunk in the ship, will it return? No. Therefore, the event has become impossible. And when the event becomes impossible, since it is another type of contract under 33, it can be enforced. Because your contract was, if it doesn't come back, it didn't come back on May 20th, and it was lost and sunk in the sea before the due date, means it will never come back. Contingent contract, to do or not to do anything if uncertain future event does not happen, can be enforced when the happening of that event becomes impossible. Since it is sunk in the high seas and it didn't return by May 20, its coming is totally ruled out, the contract can be enforced and we can ask the person to pay 1000 rupees. It can be enforced. This is regarding section 33. Go to section 34. Section 34 says, if the future event on which a contract is contingent depends on the way a person behaves and if his behavior renders the event impossible, the contract becomes void. He gives an example. A agrees to pay B a sum of money, say 1000 rupees. If C marries D, A, B, C, D are there. A agrees to pay B a sum of rupees 1000 if B marries C. B is supposed to marry C. If he marries C, he will get 1000. What has happened is that now C has married D now. Once the marriage takes place, the other event becomes impossible. Now B cannot marry C. Simple reason, she is already into a wedlock. In such a situation, the event is rendered impossible by the behavior of a certain person. Means C, by marrying D, C's behavior has rendered the marriage of B to C as impossible, and the contract of A to pay 1000 rupees to B if he marries C has become impossible, and hence it has become void. This is how the table has to be used to understand 32, 33 and 34. And once we understand this, it's very clear. If event has to happen, it can be enforced only when it happens. If an event should not happen for enforcement, then the event, when it becomes impossible, it can be enforced. And the event becomes void if the behavior of a person doesn't facilitate the event. B marrying C is ruled out because C has married D already. This is regarding 32, 33, 34. We have to see 35 and 36. For 35, 36, once again, we can use the similar template. 35 for happens, 35 doesn't happen, 36 happening of an impossible event. Let us take one by one. 35, I have made it as 35 happens. This portion is 35 happens. Contingent contract, to do or not to do anything if an event happens within a fixed time. It has to happen within a fixed time. If it happens within a fixed time, it is enforceable. If it doesn't happen within fixed time, it becomes void. We need not have to do anything. Here it says, within fixed time, if the event happens within fixed time, becomes void if at the expiration of the time fixed, the event has not happened or it has become impossible. Means we were supposed to pay 1 lakh rupees if it rains by 4 p.m. today. It happens within a fixed time. There was total fresh sky throughout the period till 8 p.m. In that case, what has happened is that the event didn't happen within the fixed time. Therefore, you cannot enforce. It becomes void. Second, it has become impossible also. Till 8 p.m. if there is no rainfall, means even up to 4 p.m. the fixed time, there is no rainfall, it is void. Read once again. Contingent contract, to do or not to do anything if a specified uncertain event happens within a fixed time, it becomes void. It becomes void if at the expiration of the time fixed, such event has not happened, or if before the time fixed, such event has become impossible. This is section 35. Event happening within a fixed time. Second, event which doesn't happen within fixed time. Contracts contingent to do or not to do anything if a specified uncertain event doesn't happen within a fixed time, enforced by law when the time fixed has expired. Take the reverse way. If it doesn't rain till 4 p.m., we will pay you 10 lakh rupees. And the 4 p.m. has passed, there was no rains at all. Doesn't happen, no rains within fixed time. When it doesn't happen, it is enforced. It becomes impossible. There was no rains for the whole day. It is enforced. Go through once again. Contingent contracts to do or not to do anything if a specified uncertain event does not happen within a fixed time may be enforced by law when the time fixed has expired and such event has not happened, no rains up to 4 p.m. or before the time fixed has expired, it becomes certain that the event will not happen. It can be enforced. This is regarding 35. Then let's go to 36. 36 says, contingent agreements to do anything if an impossible event happens, they are void. And the impossible event may or may not be known to people. They give wonderful examples. He says, if there is a railway track, two parallel lines, as per law, they cannot meet each other. They will be parallel and equidistant throughout. But someone says, if two parallel lines meet, I will give you 1 crore rupees. Or to take the example here, someone promises, I will give you 1000 rupees if sun rises in the west tomorrow morning. What is this? It is section 36. Section 36. And what does it mean? Whether you know it or not, you might not be knowing that the sun comes only in the east in the morning. Even if you do not know, the agreement is void. Contingent agreements to do or not to do anything, an impossible event, two parallel lines intersecting is an impossible event. Sun rising up in the west is an impossible event. Even if you do not know, that contract is void. It says contingent agreement to do or not to do anything of an impossible event is void under all circumstances. Happens are void whether the impossibility of the event is known or not to the parties to the agreement at the time when it is made. Now, this is regarding 32, 33, 34, 35, 36 under contingent contract. You can have a look at it, and we have to use the template to understand the meaning of these contingent contract under section 31. Now we will take up indemnity. Section 124 deals with contract of indemnity and 125 deals with the rights of indemnity holder. Just to say, a vehicle insurance is a contract of indemnity. For that matter, any insurance contract is a contract of indemnity. A contract of indemnity is a contract by which one party promises to save the other. Let us take this as an insurance company, LIC or GIC, General Insurance Company. Promises to save the other from loss caused to him, loss caused to the insured by the contract of the promisor, here the promisor is GIC, or by the conduct of any other person. Here an example is there. A contracts to indemnify B. He says, I will indemnify you if C files a suit against you regarding sum of 2000. The moment C files a case against B, he is expecting a loss to be caused to him and he will be protected by the promisor. The promisor is A. A contracts to indemnify B against the consequences of any proceedings which C may take against B in respect of a sum of 2000. It is to protect you from the loss. One protects the other from the loss. In a vehicle insurance also, the insurance company protects you from the loss from accident. What are the things? The promisee in a contract of indemnity is entitled to recover what you are supposed to recover from an insurance company here now. All damages he might have been compelled to pay in a suit which was covered by the promise of indemnity. He can also cover all costs he was compelled to pay in a suit where he did not contravene any of the orders of the promisor. GIC, when it issues a policy to you, it will say the vehicle will be driven by a license holder. The vehicle will have a valid insurance and the vehicle will have a proper license. All these conditions, these are to be followed before you make an insurance claim. Here also, in an indemnity contract of indemnity, all costs can be recovered if you do not contravene the orders of the promisor and acted carefully. Just because there is insurance, you can't drive carelessly and make an accident then say give me insurance. It says either you acted prudently and the promisor also authorized your action. If there is a suit and you defended the suit as suggested by the indemnifier, then you are entitled for all costs of the suit. What else it says? You don't want to proceed with the case in a court. You enter into a compromise. That compromise, either the indemnifier authorized or you took as a prudent person to minimize the loss, or the promisor authorized it. Whatever be the situation, be it be an insurance claim or a court case, you as a promisee or a policy holder will get all damages, all costs if the suits proceeded and there was a decision. Third, even if you don't go for a suit, if you went for a compromise, you will be entitled for all sums which are claimed under insurance or the indemnity contract. What it says? Take the case of insurance vehicle. There is an accident. The car goes to the garage and there is a repair bill of 10,000 rupees. Now the question comes, is the insurance amount a reimbursement or it is protection? Indemnity contract says, in every contract of indemnity or insurance, the person is not reimbursed, he is stopped from incurring the expense. Then who will incur the expense? The insurance has to pay directly. It is not a reimbursement. The promisee, he can seek specific performance before the damage is paid. It is not that the promisee first pays and then the insurance company comes into picture. No. The car will be repaired or replaced at the cost of LIC without making the policy holder shell out even a single rupee. Now this is what we have to remember. An indemnity is not a reimbursement. Indemnity enables a promisee to seek specific performance even before he pays for damage. Means there is a protection against damage, there is a damage, but the cost of damage will not be incurred by the promisee, it will be directly incurred by the promisor without insisting on the promisee paying any money. Now let's proceed with guarantee. Contract of guarantee is covered under section 126 and 127. Let us just understand the basic features of it. A contract of guarantee is to a contract to perform the promise or discharge the liability of a third person in case of his default. For example, you take a loan from a bank of 10,000 and the bank manager asks for a surety or guarantee. Your neighbor B gives a guarantee. When he gives a guarantee, what does he tell the banker in terms of documentation? He says, under contract of guarantee, the guarantor contracts to perform the promise in case of default of the borrower. That is what is called a contract of guarantee. He is the third party. He agrees to perform if the original party fails to pay. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of default. And in this case, we are talking of 10,000 rupees. If you give a guarantee on a continuous basis, you say, give loan to Mr. A up to rupees 1 crore, I will give guarantee for it. You may get a loan of 10,000, 20,000, 1 lakh, 2 lakh, 3 lakh, till the amount is within 1 crore. There is a guarantee given by B. It is for a series of transactions. A guarantee which extends to a series of transactions is called a continuing guarantee. A continuing guarantee, it can be revoked. You can revoke it not for the past transactions. It can be revoked at any time, but the guarantee is cancelled only for future transactions. Whatever transactions have happened, they cannot be revoked. They have got to be continued. Then, who is the surety? We took B as the surety here. The person who gives guarantee is known as surety. Who is the principal debtor? The person who borrowed. The person in respect of whose default the guarantee is given. B has given guarantee in respect of the default of A. Therefore, A is principal debtor, B is surety. Who is the creditor? Bank has given the loan. The person to whom the guarantee is given. B has given guarantee to the bank. Who has given the credit? He is the creditor. And in what form it has to be? It can be oral or written, but invariably guarantee is written with proper documentation and conditions. And now here bank has given a loan to Mr. A and there is a consideration between them. But what is this B who is a surety? What is he getting? The law protects this because otherwise any contract without consideration under section 25 is void. But the contract of guarantee under section 126 and 127 says any consideration which is passing between the principal debtor and the creditor is just enough for all purposes. It is sufficient consideration. There is no additional consideration required for surety to give. You will ask, why did you give surety? You don't need a separate consideration for that. Consideration between the creditor and the borrower is enough consideration for the contract of guarantee. Going forward, we talked of the surety who gives a guarantee. What is this? The liability of the surety is coextensive with that of the principal debtor. In the sense, if the banker wants to file a suit, he can file a suit both on the surety and also on the principal debtor or the borrower. It is coextensive and can be sued alone also. They can sue either the borrower individually or they can sue the surety individually, or they both can be sued jointly. You have given a guarantee. Guarantee is subject to certain conditions. Now, if there is a change in the terms of contract, what happens? Any variance, because there is a contract between the bank and Mr. A. This is bank, and there is a principal debtor, there is a surety who is B. There is a contract between the bank and the borrower, and it has got installments to be paid, rate of interest to be paid, and seeing this only he has given the guarantee. Now, once he has given the guarantee, any changes that is made in the contract, that should be after involving the surety. If there is something done without his knowledge, he can escape from the surety. He can say, I am discharged. Any variance without surety's consent discharges the surety as to transactions subsequent to variance. Till the contract was not changed, whatever liability is there, it continues. Whatever you changed subsequently, for that surety is not responsible. Here there is a good example. Here C agrees to appoint B as his cashier, and B has given him A has given him surety. C has taken B as his cashier, and A has given surety that B is trustworthy. And C is supposed to pay him certain fixed salary as per the agreed. Afterwards, without A's knowledge, C and B agree that B should be paid not salary but commission based on goods sold and not fixed salary. Now, this is a case of variation of terms. When A gave guarantee, B was appointed by C for a fixed salary. Means when you get a fixed salary, the risk is less. The moment you go for commission based, the risk is more. The risk is increased. But for this increase in risk, there was a variation in the terms, and the variance was not approved by the surety. Then it is discharged. The surety is discharged because of the variation. There is one more variation. Discharge by release or discharge of principal debtor. For example, here now C, B, and there is A who has given surety. B is supposed to give C certain fixed things, and he will pay him the monthly salary. If C enters into an agreement with B relaxing certain terms, take this example. A contracts with B for a fixed price to build a house. A is contracting with B to build a house, and B, who is the owner of the house, is supplying the necessary items, timber. This is the contract. If there is a variation in the contract, B was supposed to supply timber. Based on that timber, C guarantees A's performance. But later he comes to know that B doesn't supply timber at all. If one of the parties to the contract doesn't perform his contract, the surety is discharged. Here A constructs for B, B gives material, and C gives guarantee for the workmanship of A. But here B did not do his part of the job, the contract falls, and the guarantor is discharged or he is released. There is one more, where the creditors makes a composition or promises to give time or not to sue the principal debtor, the surety is discharged. Take a case. A has taken a loan from a bank and he has got monthly EMI to pay of 1000 rupees, and C has given a guarantee, and A has to every month pay EMI, and C monitors it, and his risk is to the extent of 1 EMI. And if there is one default, banker is supposed to tell C. In the meanwhile, what he has done is the creditor makes a composition with the promisee, gives him time and not to sue the principal debtor. Here he had defaulted for say 5 installments, but the bank kept quiet. It didn't file a case, nor did it inform C. It falls under 135. The surety is discharged when the creditor compounds. Means creditor fails to do the required things agreed with the surety. Under section 139, Creditors Act or omission impairing surety's eventual remedy. This is a case which clearly says, see, there is a contractor C who is building a ship for B, and every month he is paid 1 lakh. Let us suppose it has to be paid for 20 installments, and the job has to be completed in 20 months. B has given a guarantee. Every month the payment has not to exceed 1 lakh rupees and nothing to be paid in advance, because B as a surety monitors it. Here what happens is A becomes surety for C. C, without knowledge of A, has been paid 2 extra installments. There may be some control which is implemented between A, who is the surety, and B, who is building the ship for C. If B receives money in advance, the control of A is lost as a surety, because there might be some understanding between B and A that every EMI or every installment he receives, he has to share some money with A. But if the whole pending amount is paid in advance without knowledge of the surety, it is impairing surety's eventual remedy. In this case also, the surety is discharged. The surety, upon payment or performance of all that he is liable, once the bank asks the surety to pay off the defaulted amount, then the surety will get some rights. What are those rights? He is invested with all the rights which the creditor had against principal debtor. For example, there was some security with the bank. There was some pledge or mortgage made with the bank. Those properties will come at the disposal of surety. A surety is entitled to the benefit of every security which the creditor has against the principal debtor when the suretyship was entered into. Here there is a change of holder of security. When the surety was given, bank had some security from the borrower. The moment there is a default, banker has collected the money from surety. He has to hand over the security to the surety, because that will become the entitlement of the surety. Now, this is regarding surety. What is his liability? He is discharged by variation in the terms. He is discharged by release without his knowledge. He is discharged when there is a compounding done to his exclusion. He is discharged when his security is impaired, and once surety has settled the account, he is entitled for all the securities which was there with the creditor. This is all regarding surety and his rights. He is liable to pay the entire amount. What happens if there is a default by the borrower and the banker comes to the security, says pay us the money? He will say, no, you first file a case against the borrower, first finish the court case and then come to me. No, the banker can always say, whom to approach is my discretion. you cannot ask the bank to exhaust all remedies against the original debtor. Surety can be sued directly by the banker. This principle we have to be very much aware of. Banker, the surety is liable for the entire amount. It is banker's discretion or the creditor's discretion to sue, whether to sue the principal debtor or to sue the surety. It is his absolute right to go, and he will not take any instruction from the surety as to should he exhaust all remedies against the principal debtor. There are certain provisions regarding contract of guarantee which we can just go through. Any guarantee obtained by misrepresentation is invalid. Any guarantee obtained by concealment is invalid. In every contract of guarantee, there is an implied promise that the principal debtor will indemnify the surety, because whenever there is a default, the surety will pay amount to the bank or to the creditor. But what does it mean? When surety pays the amount, he will be indemnified by the principal debtor. But there is no contract, but there is an implied promise. Behind every surety, there is an implied promise that whatever he pays on behalf of the principal debtor, he will be indemnified. That is covered under section 145. And when there are co-sureties, for example, if there is a loan of 10,000 and there are 10,000 and there are two sureties, A and B, co-sureties are liable to contribute equally. Here they have to contribute 5,000 and 5,000. This is what section 146 says. But when their offerings are at different levels, we need to go to 147. 147 says co-sureties bound in different sums liable to pay equally as far as their limits of obligations. These limits are set at the inception. Let us take an example. You will understand it better now. Let us suppose there are three sureties, A, B and C. They have given a surety in respect of D, a principal debtor. A has given a surety value of 10,000, B 15 and C 20. Let us take four situations. There is a claim from the bank of 15,000. Who will pay how much? They will pay equally, because equally comes to 5,000. 5,000 is less than 10,000. 15,000 less than 20,000. Each will pay 5,000. Let us suppose the claim is 30,000. Minimum of the three is 10,000. If everybody pays 10,000, it is within their limit. They are not crossing the maximum and it is equal. What happens if there is 40,000? Minimum is 10,000. Each will pay 10,000 within the limit. With this, S limits are over. We have paid 30. There is balance 10. Balance 10 will be shared between these two. And here the limits available is only 5,000 because he's already paid 10. He will pay 5 and he will pay 5. Both will pay 15, 15. And the final payment will be 10, 15, 15. Let us take another situation of 43,000 just to understand it better. Each will pay 10,000. A is out. Then B can only contribute another 5,000. His limit is 15. Both of them contribute 5. That leaves 3,000. And the person left is only C. And his limit is 20. He can pay that 3,000. And they will pay 18,000. In the sense 10, 15 and 18. This is the illustration for this clause which says co-sureties bound in different sums liable to pay equally as far as the limits of their respective obligations. They may set limits at inception of contract. And there is one more. If the surety dies, the contract of guarantee is revoked, but it is only for future. His property will be liable for transactions of the past till his death. We can also understand the difference between a contract of indemnity and guarantee. Guarantee involves surety. Indemnity is just like an insurance. We can just see indemnity saves from loss cost. It is depending on a contingency, just like insurance. Whereas guarantee performs promise of a principal debtor. It is talking of an existing debt. It is no contingency. Nature of business. Normally, indemnity relates to insurance and guarantee relates to a loan or borrowing. Format of contract. In case of insurance or indemnity, the basic spirit will be, I will see you paid, and the policy is issued by the indemnifier. Whereas in case of a borrowing, the surety says, I will pay the bank if the borrower doesn't pay. And who goes after the surety? The borrower goes to surety and requests him to sign the surety to the bank. Responsibility. Primary responsibility in respect of insurance contract, as we said, it is the insurer who has to take responsibility for payment. It is not reimbursement. In case of guarantee, it is the borrower who has to pay first. If he fails to pay, then the banker comes to the guarantor. Therefore, borrower is primary responsibility, surety is secondary responsibility. Parties to the contract. Here, in case of insurance, indemnifier and indemnified, insurance company and the insurance policy holder. Whereas in case of guarantee, there is a banker, borrower and the guarantee. In case of indemnity, there will be one contract between policy holder and the insurance, whereas here there will be three. One with the bank and the borrower, and second bank and the surety, third with the borrower and surety. Totally, there will be three contracts involved in case of surety. Section 10 on essentials of a normal contract applies to all the contracts, and utmost good faith, ubarime fidei, applies to indemnity. Privity of contract. In case of insurance contract, the insurance party is a stranger to the contract. It cannot sue a third party because the contract was only between the two. But in case of surety, there is a tripartite agreement between the borrower, banker and the surety. He can sue a third party in his own name. In the sense, a contract of guarantee is more stronger in terms of invoking the rights of the party, whereas in case of insurance, it is only the indemnifier considered as a stranger. He cannot file a suit against outsiders on the strength of this contract. Let's get into the bailment as a special contract. Bailment under section 148 indicates delivery of goods by one person to another for some purpose. We give a car to the mechanic for repairs. It is delivery of car for some purpose, means repairs. Upon a contract that when the purpose is accomplished, the goods shall be returned. Means when the repair is over, the car will be returned to us. Either it will be returned or it will be disposed of according to the directions of the persons delivering them. We may either ask the garage person to give the car to us or to deliver it to someone else or deliver it to our office. This is the basic feature of bailment. Delivery of goods for some purpose upon a contract that when the purpose is accomplished, the goods has to be returned and disposed of according to directions of the person delivering them. One thing you have to remember here, the goods are to be returned what we gave. It cannot be different goods. You deposit money into bank. It comes back to you when he gives it to you. It is not bailment because he is not giving you the same things which you gave him. When you give a car for repair, you get back the same car. When you give something for alteration of jeans, trouser, same trouser you get back, but it is not the same thing with the bank. This is the specific feature of bailment. Return of the same goods is what makes the difference. Then next feature is delivery to Baily. We have to give the car to the garage. The possession has to be given to him, to the Baily, made by doing anything which has the effect of putting the goods in the possession of the Baily or the person authorized by him. There is delivery involved in a Baily. And the Baler is bound to disclose the fault in the goods. For example, you are giving on hire a horse to people. When you are giving it to them, you are giving it on bailment. They are supposed to return it to you after their ride. Then you are supposed to tell them the problems with that horse or the intimate features with that horse which they should be careful about. The bailer bound to disclose faults in the goods which materially interfere with their use. Particularly when it is given for hire, if there is a damage caused from such faults, the bailer will be responsible. Such is the importance of duty to disclose faults, more particularly when you are bailed on hire. Baily to take care. He must take, Baily means the person who receives the goods. He should take as much care as a man of ordinary prudence would take of his own. If I leave my car in the garage person has to take care of my car as if it is his own car. That is the standard of care and protection he has to give to the goods. And the Baily should avoid inconsistent acts in respect of the goods. Car is given for repair, not to go around the city. A contract of bailment is avoidable at the option of the bailer. We have given it, for example, a suit for ironing. It is not for wearing it and then going to attend a marriage. Baily's inconsistent acts will give the bailer an option to avoid the contract. Maybe it will attract damages and claims. For any unauthorized use of the goods, Baily is supposed to make compensation to the bailer for any damage arising to the goods therefrom. And what is important here is when we give it to the Baily, possession with the bailer is important. For example, you have got something given to your servant. The servant may be having a custody, but he doesn't have the possession. Possession is a feature of ownership. When you own the product and you have the custody, custody with ownership makes possession. Only a person in possession can make a bailment, not otherwise. Under bailment, we can just see what is the effect of mixture with bailer's consent. When the goods are mixed, we will take one by one. The bailer and the Baily shall have an interest in proportion to their respective shares. For example, you have got 1 quintal of paddy. You give it to someone who mixes with his 2 quintals of paddy. Then we will share it in the ratio of 2:1 because they are homogeneous products and there is a consent of the bailer. What happens if the mixture is done without bailer's consent? Section 156 and 157 deal with it. When the goods can be separated, he has mixed it without our consent. The Baily is bound to bear the expenses of separation and any damage he has to bear because we did not allow the mixture. He did it without our consent. Okay, that is when the goods can be separated. What if they cannot be separated? If the goods cannot be separated, it is an error of the Baily and Baler is entitled to be compensated by the bailee for the loss of goods. He has to make compensation to the bailer. Third one, repayment by bailer of necessary expenses. The bailee, when he is having the goods, he must have spent some money. He is to receive, when he is not receiving any remuneration, the bailer shall repay all necessary expenses for the purpose of bailment in preserving whatever we gave and whatever services he lent. Repayment by bailer of necessary expenses covered under section 158. Restoration of goods lent gratuitously. When the goods are given free, a book is given for personal reading. The lender of a thing at any time may require its return, even though it was lent for a specific purpose. The beauty is, when you give it for a non-gratuitous bailment, you cannot take it back immediately. The period has to be covered. But when it is given free, lent gratuitously to somebody, even if the period is not completed, the bailer can call back and take the goods back. What is Baily responsibility under section 6161? On expiration of time or accomplishment of purpose, he has to return the goods bailed. If he doesn't return, he will be responsible for any loss or destruction from that time. For example, say 31st December, he was supposed to return the goods. He doesn't return, and that is a default. If the goods are destroyed in a fire after 31st December, bailee cannot run away from the responsibility. He shall be responsible for any loss, destruction or deterioration from 31st December, the last date which he was supposed to give the delivery. Otherwise, normally risk goes with the ownership of the goods. Ownership is with the bailer, but here the bailee defaulted in returning. That is the reason he has to carry the risk. Then, for example, you have given a cow on bailment to a person to keep it for 1 month, and during this 1 month, if it lays a calf, the cow and calf both belong to bailer. Bailee is bound to deliver to the bailer any increase or profit which have accrued from the goods bailed. Goods includes animal also. The bailer responsible to the bailee for any loss sustained if the bailer was not having title of making the bailment and receiving back. For example, you have made a bailment, given some gold to a goldsmith to convert it into ornaments. After he has collected the gold, police have come and arrested him, stating the gold which you gave were stolen goods. In that case, the bailee has incurred a loss. He has incurred inconvenience because the bailer was not entitled to make the bailment and he is not entitled to receive back the goods. In that case, the bailer is responsible to compensate the bailee. And if the bailer has no title to the goods and the bailee doesn't know it, he delivers back to him, and next the owner comes. Owner of the goods come to bailer, says, bailee says, why did you give it to the bailer? He is not the owner, I am the owner. But bailee doesn't know. He has acted in good faith because he received from you, he returned it to you. When he does it, he is not responsible to the owner. This is clear in section 163 and 164. Basically, when it is mixed with authority and expenses incurred by the bailee to be paid by the bailer, goods given gratuitously can be called back anytime. Bailee's responsibility for destruction if the goods are not returned in time, and bailee has to be compensated for any loss suffered by him due to lack of title, and bailee is supposed to return the goods with any incremental benefits which he has received during bailment. If the bailer doesn't have ownership title, Bailey is excused for delivering it to him and not responding to the real owner. This is regarding section 155 to 64. Now we have got to have a look at the bailment under finder of goods, which we covered under section 71 quasi contract. The same thing is covered here once again. Right of finder of goods, which we covered under 71, is repeated under 168. Right of finder of goods, he may retain the goods until he receives such compensation to preserve the goods and to find out the owner. Where the owner has offered a specific award, he can sue for such award and retain the goods until he receives it, which we said: protect, not to mix, search and return, try to find perishable goods to sell, and he has got the right to lien, compensation and reward, as seen in Lalman, Shukla and Gauri Dutt. And finding the seller, which we once again mentioned here, is coming here once again. If the owner cannot with reasonable diligence be found, or if he refuses to pay the lawful charges, the finder may sell when the thing is in danger of perishing, or when the lawful charges amount to 2/3 of its value. This, and it comes to lien. We talked of the lien also here under section 170, where the bailee has rendered any service involving exercise of labor, he has the right to retain such goods until he receives due remuneration for the services. This is finder of goods, who is considered as a bailee, and he has got these provisions of 168 to 170 empowering him. And as an extension of bailment, there is pledge. When the pledge bailment is used as a security for borrowing, it is called as pledge. Let us see the features. Bailment of goods as security for payment of debt for performance of a promise is called pledge. The bailer is called the pawner, and the bailee is called the pawnee. Function remains the same. The pawnee, just like a bailee, may retain for payments of debt, for interest on debt, and all expenses incurred for possession and preservation of the goods pledged. And pawnee not to retain, he can retain the goods, whatever is given to him, but only for this particular debt where it is given as a security. He cannot use it as a security against all other dues to him. Pawnee not to retain for debt or promise other than for which goods were pledged. It is one-to-one relationship. The pawnee is entitled to receive extraordinary expenses incurred for preservation of the goods, just like a bailee. He can bring a suit against the pawner and retain the goods till the suit is cleared for payment. He can sell the goods pledged if it is not taken away in the regular time after giving notice. He can sell it, and when he sells it, if there is a shortfall, the pawner has to pay the balance. He can claim it, bailee can claim it, or pawnee can claim it from him. If there is a surplus from the sale, he shall pay over to the pawner. Means the pawnee will collect what is exactly his due. Surplus he will hand over, shortfall he will claim back. The pawner in default, he has not paid the money and his goods are still there, they are getting sold. He can still have an option. He can redeem the goods if it is not yet sold at any subsequent time after the delay, before their actual sale, but he must pay all expenses which have arisen from the default. This is regarding the pledge. Pledgee can pledge only to the extent of his interest. Means he has pledged with a pawnee. Can he take it to another pawnee and then he can pledge? It is permitted. A person who has lent against an item can take a loan against that item from another lender. That is called pledge by the pledgee. to the extent of his interest. For example, he has got a pledge for 1000 which is in default. He can pledge the same instrument with another pawner and collect 1000 from him, which is permitted. And pledge is being done by mercantile agents, and pledge is also permitted when you have goods under voidable contract with you, provided it is done in good faith. Let's look into agency, the last of the special contracts. Under agency, we will be covering the basic features and the authority of the agent and the principal. Let us get going. An agent is employed to do any act for another, or he acts for another or represents another in dealing with third parties. So to say, if he has a principal, he acts for the principal or he represents the principal with a third party. These are the acts of the agent, with the third party or to do any act for the principal. The person for whom the act done or who is represented is called the principal. Fine. Who may employ an agent? An agent can be employed by a person who is of the age of majority and sound mind. Means he should have capacity to enter into contract. As simple as that. Who may be an agent? Agent can be any person. But no person who is not a major and who is of sound mind, who is not of sound mind, can become an agent, because it is a job of responsibility of dealing with people. It requires maturity and sanity. That way, though anybody can be an agent, it is preferable that he is a major and he is of sound mind, because it involves entering into contracts. For creating an agency, there is an exception in section 25. No consideration is necessary for creation of an agency. Anyone could be appointed as an agent without any consideration. And invariably, agent's authority is express, but sometimes it is implied, inferred from the circumstances. For example, when goods are consigned on a ship, and if there is a requirement to reduce the weight of the ship, the goods are thrown out of the ship. How does a captain of a ship throw the goods belonging to the principal? In an emergency, he implies an agreement of agency with the principal owner of the goods, and with that implied agency, the goods are thrown off the ship to save the ship and lose the consignment in the process, using the implied contract of agency. Agent's authority. Once we appoint an agent and ask him to do certain things, he gets authority to do every lawful thing necessary to perform the authorized act. He need not have to be empowered for everything. The moment he is given a job, he gets the authority automatically to implement that job. And a few more things regarding agency. An agent, can he delegate to his subordinates? It all depends. If he has undertaken to perform his job personally, doing a painting for somebody, he cannot do an agent. But if the customs of trade permit it, he can appoint an agent. Agent's agent is called subagent. An agent appointed by an agent, and the subagent reports to the agent only. Subagent. A person employed by acting under the control of original agent is called subagent. What is the relationship? Now there is agent, there is subagent, and there is principal. What is the relationship between the three? The principal is represented by the subagent. When the subagent deals with third parties, he represents the principal to them, though he is a subagent. And the agent is responsible to the principal. Whatever subagent does, it is the responsibility of the agent to protect the interest of the principal, and he is answerable. Subagent doesn't directly come in contact with the principal. The subagent is responsible to the agent. There is a relationship between subagent and agent. But there is an exception. Wherever there is fraud or willful wrong, the principal can directly deal with this person and take action against him, which is legally permissible. That is the binding relationship. There is one more set of agent called substituted agent. Every agent appointed by the agent need not have to be subagent. He can be substituted agent also. Means a substituted agent will not be reporting to the agent, but he will report to the principal. Who is he? For example, if there is a property with the agent belonging to the principal, principal wants to sell the property. For selling the property, principal tells the agent, appoint a lawyer. That lawyer appointed through the agent is not subordinate to agent. The lawyer reports to the principal. And such agency created through the lawyer is called substituted agency. When an agent authorized to name another to act for the principal, he directly reports to the principal. In the business of the agency, has named another person who is not a subagent, but an agent of the principal. A parallel agent of the principal appointed through the agent is called substituted agent. We have the lawyer's example. Ratification. Agent does some work, but it has to be authorized by the principal. That affirmation of authorized, unauthorized acts at the origin is called ratification. Principal approves an unauthorized act done in the past in the interest of business. And once you affirm or authorize, the authorization dates back to the date of original agreement, original day of the act. Ratification may be expressed or implied. And when one ratifies, he should know the full facts. You can't just ratify on the superficial knowledge of it. And there should be no material defect in the whole ratification process. And ratification cannot be in part, it has to be full. Whole act is to be ratified. And when you ratify an act, it should not result in an injury to a third person. It is for protection of interest and with no hurt caused to any other parties. And that is the significance of ratification under 197 to 200. And in some cases, the agent is personally liable. What are those cases? When he acts for a principal who is outside the country, a foreign principal. Therefore, people will fall back on the agent directly. When he has dealt in but not disclosed the principal's name, then he attracts personal liability. He has dealt on behalf of a principal, but that principal was incompetent. Maybe he was a minor or a person of unsound mind, then the responsibility falls on the agent. And he pretended as if he was an agent, but he was not an agent, he was pretending as an agent, then he is personally liable. And there are also cases when an agent does certain things which are not approved by the principal, then those acts become acts exceeding authority in breach and they become personal liability of the agent. This is the personal liability instance to be remembered. Then comes revocation of authority of an agent. We can just have a look at the provision as such. An agency can be terminated by the principal or the agent himself can renounce and resign, and the agency comes to an end at the end of the business or business task which was proposed in the beginning, just like a partnership at will or particular partnership. And if principal or agent, if any one of them dies or becomes unsound mind, the agency is terminated. And insolvency of the principal. It is only the insolvency of principal which terminates the agency. Insolvency of agent is of no consequence. It doesn't affect his capacity to act as an agent. These are the 5 situations when an agency is terminated. But termination cannot take place when it is coupled with interest. For example, you have got a relationship with B, and B has taken a loan from us of 10,000, let us suppose. Then A appoints B as an agent and says, out of your monthly commission of say 20,000, I will recover 1,000 per month. Therefore, you will work with me for a minimum of 10 months. Just to put it clear, A is the principal. He has got a relationship with B. He has lent money to B 10,000. And to recover that 10,000, he appoints B as an agent for some other business wherein the monthly commission is 20,000. He says, I will recover 1,000 per month and you can be with me for 20 months. It's a commitment. Therefore, this agency where the monthly remuneration is 20,000, out of which 1,000 is recovered, is an agency coupled with the interest so far as B is concerned. Because if this agency is cancelled, he will not find an option to repay the loan of 10,000. Where the agent has himself interest in the property which forms subject matter of the agency, and the agency cannot be terminated to the prejudice of such interest. He has got an interest involved in this, it cannot be terminated. Where the principal may revoke agent's authority, where does he? He is given so many powers, but once he starts invoking the powers, principal cannot withdraw, but he can always revoke before the powers have been exercised. Means once used, exercised partially or fully, it cannot be revoked. Third, revocation where authority has been partly exercised. The principal cannot revoke authority given to his agent after the authority has been exercised even partially. Where there is an express implied contract that the agency should be continued for a period of time, he must make compensation for premature revocation. For example, he has been appointed for 20 months and you want to revoke in 10 months, he can claim a compensation for termination of contractual obligations. And how renunciation is made and when effective? Revocation and renunciation could be expressed or implied, but there should be a reasonable notice must be given whoever is revoking it, principal or agent. And when it will be effective, knowledge is important. When agent's authority is terminated, there should be a communication and it should come to his knowledge. Once it comes to his knowledge, then it is effective. If it pertains to third persons, the termination notice has to come to the knowledge of the third person, then only it becomes effective. Renunciation, mode and when effective. We have got 4 more things. What is agent's duty to the principal? Simple routine jobs. Conduct the business as per directions of the principal. Be careful, use reasonable diligence and skill. Compensate the principal if there is any negligence happening from your side or there is want of skill or misconduct. Render proper accounts to the principal. Always communicate diligently with the principal. Don't have conflict of interest. And anything that you do unduly gaining, agent has to pass it on to the principal. This is agent's duty to the principal. And agent's right of retainer, he can hold the goods and papers of the principal. Out of the sums received, he can retain all monies due to him towards expenses properly incurred, and all such remuneration payable for such acting as agent. But when business is not conducted properly, he is not entitled to remuneration. Agent's lien on goods, papers and other property until the amount due to him has been paid. These are the strong rights of the agent against the property of the principal for recovery of amounts due to him rightfully. Principal also has some duties to the agent. The agent has to be indemnified for all lawful acts. Agent has to be indemnified for acts done in good faith. But agent will not have the protection when he is involved in a criminal act, which is not the liability of the employer under any circumstance. And if injury is caused by principal's neglect, principal has to compensate the agent. And for enforcement and consequences of agent's contract, principal is always accountable because it is a master-servant relationship. Whatever the agent does, it is on behalf of and for the principal. These are principal's duty to agent. When agent exceeds authority, he attracts personal liability. That's very, very clear. Section 227, 228 and 229. When a part of what he does within his authority can be separated, what is within his authority is binding between him and principal. If it is not within his authority, if it is beyond the scope of his authority and cannot be separated, principal is not bound, it becomes personal liability of the agent. And any notice given to the agent is notice given to the principal so long as the third parties are concerned, and it has got legal consequences as if the information was obtained by the principal. That covers the special contracts. And reviewing back into the details of components that are there in the Contracts Act, it is quite comprehensive, quite useful, and it is day-to-day impacting also. Thank you so much. Thanks a lot.